I have that question asked by a lot of clients, and the answer in the state of Wisconsin is there's a statutory 120-day waiting period before you can be divorced. And that is triggered not when you decide you're going to file, or even actually when you file your papers at the courthouse, but it's triggered when the other person is personally served with the divorce papers. After the 120-day cooling off period, you can be divorced anytime once you reach an agreement. I tell my clients that the average time from beginning to end to get a divorce is about 6 to 9 months in the state of Wisconsin. Now, sometimes things can be complicated if there's custody of children, if those issues are contested, if it's a large estate, and perhaps depending upon whether you're in a large metropolitan area or in a rural area, there could be extra added time onto the length of getting a divorce. But on average, my experience has been about 6 to 9 months from beginning to end. And then after you're divorced, there's a 6-month waiting period before you can get remarried anywhere in the world. So give or take, figure it's about a 6 to 9 month, maybe as long as a year process from beginning to end. That's a really good question as well. And most people sort of confuse the terms custody and placement, so I'd like to sort of distinguish them for you. Custody is decision making. It has nothing to do with where the children are going to live. And in Wisconsin, and it's been the law for a number of years, there's joint custody. And joint custody means that both parents have equal input and say-so over major decisions involving their children's upbringing. And those decision-making topics involve such things as religious decisions, schooling decisions, health decisions, when a child may be old enough to drive a car. Sort of day-to-day decisions each parent makes on their own when the children are with them, but major decisions, both parents have equal footing and need to discuss those issues. If a parent has sole custody, that means that that parent is allowed to make all major decisions involving the children without input, without equal say-so from the other parent. So that's custody. Placement has to do with where the children are going to live. I want to sort of give you a quick history lesson. In the past, a number of years ago, most courts, if custody and placement was contested, most courts usually placed children predominantly with one parent, and then the other parent would visit the children typically every other weekend and perhaps once or twice for dinner during the week. And more often than not, that perhaps was the mom, the wife. About 15 years ago, Wisconsin created a equal placement law in the state of Wisconsin. And that statute allows the court to set what's called significant and meaningful periods of placement with both parents when they get divorced. Again, sometimes we do see traditional placement arrangements in the state of Wisconsin, but more often than not, parents are sharing children. They do have equal placement. And parents can agree as to those things, and if they don't agree, then the court will decide the placement of the children. And there are a number of factors that would go into the judge deciding where the children are going to live. The wishes of the children may be a factor. It is considered, and the wishes are conveyed by a court-appointed guardian ad litem for the children. Historically, what the relationship has been between the parents and the children, their health issues, education, religious choices, the parents' ability to cooperate and get along with one another, the parents' ability to understand and recognize involving the other parents' involvement in the children. There are many statutory factors that the court would consider in the placement of the children. In the event that you and your spouse cannot agree as to either custody or placement and those issues are contested, typically what will happen under the statute is the court is going to order both of you to sit down with a court mediator to try to resolve those issues. If you're able to reach an agreement at mediation, then one of the attorneys, or if you're pro se, you would be required to draft a formal agreement, a stipulation and order that would be submitted to the court for approval, and that would be binding as to custody and placement. If you don't reach an agreement at mediation, then usually the next step in most counties is the appointment of what's called a guardian ad litem. That's an attorney that the judge appoints from a list that's maintained by the court of various attorneys in the county who are experienced in family court matters, children's matters, etc. And they become an advocate and represent the best interests of the children. And they ultimately make recommendations to the court about the placement of the children or custody if that is contested, after interviewing both spouses, perhaps meeting the children and talking to other collateral sources to get as much information as the guardian ad litem feels is necessary to make recommendations on the children's best interest. Some counties also have an internal department, family court counseling services with social workers that will also appoint a social worker to make an investigation as well as to the best interests of the children, what custody should be, what the placement of the children should be. That can get to be a long, involved process, and that actually can get to be a very long and expensive process as well. So it is always better, if you can, to try to reach an agreement as to custody and placement of the children on your own. Try to remember both parents have a right to be involved in the children's lives, all things being equal. And if you have to go the route of contested litigation over custody and placement of your children, you should involve yourself with a skilled family lawyer to assist you and help you to explain what your chances are, how long it's going to take, and what the expense of that may be to you. There are actually two different formulas in the state of Wisconsin for calculating support, so I'm going to go through both of them with you today. The first one is if one parent has primary placement of the children, and that's defined as the parent has 75% of the time during the calendar year, usually counted as overnights. Then there's a specific formula for calculating support. It is 17% of gross monthly income for one child. It is 25% of gross monthly income for two children. It is 29% of gross monthly income for three children, 31% for four, and then there's a structure up to 35% beyond a family having more than four children. It is counted as the non-custodial parent paying child support from their gross monthly income, not net. A lot of people ask me that. It's not from your net income. It's calculated from your gross income. And child support orders are also taken by income assignment, meaning that the person who's paying support will actually have those payments taken directly from the payroll checks at work in the same manner that they get paid. So if they're paid biweekly, the checks are going to come out, the payments are going to come out biweekly, and those are processed through the court system throughout the state of Wisconsin, and you receive the checks that way. And I believe there's also a way that you can have direct deposit of those monies. The other formula for calculating support assumes that parents have either a shared or equal placement arrangement. So this is a non-traditional placement, and this formula considers how much money each parent makes, what their gross monthly incomes are, and what percentage of time both parents are sharing with the children. So in order to run that calculation, you need to know what are the number of overnights that both parents are spending with the children, what did they both make per month gross, and then you put that into a formula under DCF guidelines, and that will give you the calculation whether one parent has to pay support to the other based upon if one parent is making more, or if it's not exactly 50-50, one parent has more time. It may turn out when you run the formula, if the parties' incomes are about the same, and if they're having 50-50 placement of the children, that there may not be any child support order at all. Also, in situations where parents are sharing children or there's equal placement, there should be a provision under the statute that parents pay for what are called variable costs. And those are expenses over and above what child support covers. Child support is designed to cover basic necessities of life: housing, clothing, food. Variable expenses are things such as field trips, extracurricular activities. If the children are older, there's sports activities, other miscellaneous expenses that are not necessarily labeled necessities, parents cover those variable costs in their divorce agreement or in the court orders by a formula that's similar to shared or equal placement. And by that I mean it compares what percentage of time the children have and how much they both make. So there's a pro rata formula for how both of them contribute to miscellaneous variable costs of the children. You know, this is a frequently asked question, and of course it's of concern to anybody who may be facing a divorce. And ironically, I don't think most lawyers like to say, or they don't want to say, what the divorce is going to cost. Not because they don't want to be honest and tell a person what it may cost, but they're nervous that if they give you a quote or they tell you or give you an estimate of what it's going to cost and they're wrong, that you, the client, are going to get very angry about that. And I certainly understand that mentality. But I always sort of think on my own, would you buy a house without knowing what it's going to cost you? Would you go to a showroom and look at a car and buy a car without knowing what the price of that car is? And the obvious answer to those questions is no, nobody's going to do that. So I think you, the client, do have a right to know ultimately, generally speaking, what is the divorce going to cost you? And an experienced family lawyer can sit down with you, understand the facts of the case, how long you're married, what the potential issues may be, the other factors that go into determining what the divorce is going to cost you is the experience of the attorney. Usually younger lawyers who are a few years out of law school have a tendency to charge lower hourly rates. And that could be estimated in the $150, $200, maybe even $250 range. And their retainers, the advancement that you pay to hire the lawyer, is usually on the lower side, anywhere perhaps from $750 to $1,000 to maybe a couple of $1,000s. The more experienced family lawyers who have been practicing 20 years or more, you will find that their hourly rates are much higher, usually starting at $250, perhaps $300, and maybe as much as $400, $500, $600 in major metropolitan areas. Also, their advancement, the retainer, is much larger for the more experienced lawyer. It's not unusual for a lawyer who's practicing 20, 30 years to demand a retainer of $3,500, $4,500, $5,500. So you will find lawyers can do the same thing. They can all get you divorced, but their experience, their skill, the numbers of years in practice, their reputation in the community, the prices are going to vary depending upon what lawyer you talk with. The less experienced, the less cost. The more experienced, perhaps the more cost. But the old saying is, you sort of get what you pay for. So don't just shop for the cheapest attorney in town. You have to shop for a number of different factors and consider, is this attorney the right attorney for me? Do I like their personality? Do they seem to care about me? Do they spend time with me when I first meet with them? Do they charge me for the initial consultation, or is it a free visit? We historically have never charged clients who have come in to see us for an initial consultation. It is always free. But there's a number of factors that go into deciding what lawyer you should select and what is the divorce going to cost you.